And as you might imagine, as the deadline approached, there were quite a few Oklahomans that got information in toward the end and actually on the deadline. And we've actually reviewed over 400 files that have been filed with the office. And more than review, they've been vetted and investigated and great care taken to find out exactly the extent of harm that each of those respective Oklahomans experienced. And that really, at the very beginning, was our focus, was to make sure that the unlawful conduct that servicers engaged in Oklahoma, the robo-signing and the dual-track processes that we experienced here, that Oklahomans, as they suffered, that we made sure that they were compensated, that restitution occurred, and that they were, their harm was addressed. And so that's been our focus since the settlement was announced, but even more since the deadline passed, because there were quite a few that came in toward the end. Our claims are averaging about 11,000 plus per claim. We've had many that have received the maximum of 20,000. Compared to the national settlement, there's not been one check issued yet at the national level. And it is estimated that when those checks are issued, that quite likely they will be less than $1,000 apiece. And what's really troubling about that, Brianna, when you think about what my role as an Attorney General or other Attorneys General across the country, our job is to take existing law and make sure that as people violate that law and harm occurs, that those folks are compensated and taken care of. And that national settlement was almost like a plaintiff's lawsuit, you know, where you get this class action notice in the mail by a plaintiff's attorney saying, hey, would you join the class action? And about a month or two later, or 6 months later, you get a coupon in the mail. And unfortunately, we're seeing some of that kind of dynamic with the national settlement, where individuals suffered true harm. They lost their home through unlawful practices by a servicer, and they're going to get a check arbitrarily, likely for less than $1,000 for that harm. So Oklahomans are being served by the settlement in a very meaningful way, and we're very intent on making sure that we go through those files and harm is addressed. Well, there's a range that was established, minimum of 5,000, maximum of 20,000, and to your question, there were factors that we considered through the investigation process that we attributed an index to. So if you went through robo-signing or dual track or you lost your home, those were all factors that were considered in the review of the file to determine how egregious the conduct was. And so that's what we focused on in assessing the harm. You know, the other thing that I think is important about that, Brianna, is that this wasn't simply an application that came to us and we looked at the application and kind of made a decision. Applications came to us with documentation behind it, and then interviews took place. We spent time with the homeowner talking to them and really evaluating in a comprehensive way the file. That gives us the ability to determine with more certitude the extent of harm. Again, as compared to the national settlement, that's not happening. Applications are made, and there's just simply going to be an arbitrary, based upon the number of folks that have applied, they're just going to divide that by the amount of money in that bucket and just send out checks to those individuals. We didn't do it that way. We went on a case-by-case basis, dedicated resources of this office, attorneys and investigators, to spend time with homeowners, individuals in the state, to assess the extent of harm and then put a real number on the amount of harm that they suffered. So the index was a guide. The index it governed our process, but what really drove the outcome was the extent of harm and the information we gathered in that investigation process, where we could really assess the type of harm that those homeowners suffered.